Welcome back. Now, the Supreme Court has overturned the 1998 verdict granting immunity to MPs and MLAs from bribery charges related to the votes in the Parliament and legislative assemblies. Ashmit joins us with all of the details on this. Ashmit, take us through the verdict.
Well, a landmark judgment coming in from the Supreme Court. The question whether or not MPs and MLAs enjoy immunity even if they accept bribes for casting their votes or making speeches in the Parliament or the state assemblies, that question has been answered unanimously by the 7-judge bench of the Apex Court. The Supreme Court giving a big no. There is no immunity from criminal prosecution in case of MPs and MLAs accepting bribes. And not just that, the Supreme Court clarifying that they can also be charged and acted against under the Prevention of Corruption Act. Very clear words coming in from the Apex Court. Today's judgment of the Apex Court seeks to undo the 25-year-old judgment of the Apex Court in 1998, which had granted this protection to MPs and MLAs under Article 105 and 194. The Supreme Court today, however, differing with that judgment, making it very clear that this is not in keeping with our constitutional ideals, this is not in keeping with probity in public life, that this cannot be permitted. MPs and MLAs do not have unchecked parliamentary privilege. This is certainly not a case of parliamentary privilege which can be allowed in case of corruption, accepting money, in case of quid pro quo. The Supreme Court also holding that this can be vastly damaging for a functioning parliamentary democracy, and that such principles of immunity are not sustainable in light of our constitutional ideals. So a strong message being sent out here by the Apex Court: no immunity to MPs and MLAs from criminal prosecutions in cases of bribery.
All right, Ashmit, thanks a lot for that. Like you said, landmark judgment really today. But with that, it is time for a short break.